the chapter 5, sorry, and then we will start discussion on the chapter 4, that is on the accomplice, or you can say approver, sarkari gawa, sultani gawa. So there are various name of this approver or the accomplice. Okay. First, I'm taking, if you see in your case material, the syllabus, in the chapter 5, it is divided in two parts, A and B, and A part has three subparts: child witness, dumb witness, and hostile witness. So far, child witness and dumb witness we have discussed, and now the left we have left hostile witness, so that we will discuss, and then the part B, examination, cross examination, and re examination, and the case on the hostile witness, State of Bihar versus Laloo Prasad. So these things we will discuss. See, if you read section 137, you will find that how a person who come before the court, he has to be examined. The first is that the person is examined by the party who call the witness. Okay. The second is that the opposite party, means the party other than who call the witness, then will examine, and this is known as cross examination. So the first, when the party who call the witness examine, that is known as examination in chief, or in the court, in the common practice, we say chief chal raha hai. When the other party examine the witness, it is known as cross examination, and the cross examination has its importance because to find out the truth, to impeach the credit, to know the veracity, it is very important to cross examine the person. Suppose there is a trial and A is accused. Allegation is that A killed B. There is one person who called by the prosecution that this person C saw A killing B. Now in the examination he described the story that at that day I was standing there, then I saw all these things. And then the opposite party, that means the defense side, has to cross examine that आप कहाँ रहते हो? Okay, so you are not living there, so why you went there? And many other things also ask, that his party inform him, and by this cross examination the truth has to be find out. So the cross examination has that much of importance. In the cross examination, if something come out from the witness and that has to be clarified, or that has to be rectified, then again the party that call the witness can examine it, and now this examination is known as re-examination. So this is the three level of the examination, and section 137 talk about this. Now there is certain rule, I think in earlier classes also somehow some little we have discussed, that what question cannot be asked in the the examination in chief. So there is the concept of leading question. Leading question means such question that suggesting the answer. When a question that put before the witness, and this question suggests itself the answer, then you can say that actually the witness is not telling, but you are hinting that what the witness has to say. Like you ask that okay, उस दिन आप वहां पे खड़े थे, तो यानी उसको हाँ बोलना, हाँ अच्छा आपने मर्डर करते हुए देखा, okay, okay, you saw that A was running after B and A stabbed B. So no, this type of the question, this is the leading question that suggests the answer. So that cannot be asked, one can object it. So section 141 define leading question. So all these things. We will discuss these in detail, but before that, the thing is that suppose a person called a witness, and he called a witness definitely because he want his statement in his favor. Like in this situation, we say that the prosecution called the witness, and Mr. C has to say that how A stabbed B or the story, whatever he was aware, he was having the knowledge. But the party who called the witness, this witness either saying that I have not seen anything or I was not there. Though in the statement, in the charge sheet, there is the statement of this person, or he tells some other story that is not favorable to the person who called him. Now, the question is, see the problem. This type of the witness is known as hostile witness. Problem is, suppose A called a witness. So he will ask in the examination that, okay, aap bataiye how all these things happened. Now A is telling, उसको कहना था कि ए ने बी को मारा, और उसने कह दिया कि जी मैं उस दिन था, कोई एक और आदमी था जिसने बी को मारा, ए ने तो नहीं मारा. Now who can cross examine? Only the opposite party cross examine. And this statement, this oral evidence, this testimony is favoring the defense. So the defense तो नहीं करेगा क्रॉस एग्जामिन में कि भाई आपने पहले ये स्टेटमेंट में लिखा हुआ था कि ए ने मारा, अब क्यों कह रहे हो, क्योंकि उन्होंने तो ए को बचाना ही है. And because the cross examination right is in the opposite party, so the person who called the witness cannot cross examine कि आपने पहले ये किया था, to show the prior writing etc. And that's why in cases of hostile witness, or in cases of a situation where it comes that for finding the truth, to check the veracity of a person, it is advisable to ask some question that the party can ask in the cross examination. And this is something that section 154 has. So section 154 is basically known as hostile witness, or the provision related to hostile witness. But when you will read the documentary books, judgments, you will find that section 154 is not limited only to the hostile witnesses. Yes, hostile witnesses, in the cases of hostile witness, yes, section 154 is helpful, because section 154 give the right that the party who call the witness can ask the question that can be asked in the cross examination. But it is not saying that this situation or this section 154 is applicable only and only in case of the hostile witnesses. And so the authors say that in many other situations, for effective and successful conclusion of trial before it is satisfied that witness is alleging, if the court, though on material placed before it necessary to extract the truth, does not permit examination of such witness by the party who has called the witness, in that situation, if the injury will be caused to the whole case, whole justice system, and so in that case it can be given the right to the, or the chance to the party who call the witness. Again, the next thing is that when we read section 154, it does not say that at what stage a person is allowed, at what stage the court can give the permission, can permit the person put the question that can be asked in the cross examination. So, so that is also that it's not clarifying at what situation it can be at any stage. Now come to the section 154. When you read section 154, you will not find the word like hostile witness. But if you see the case material, the topic is of the hostile witness, like the child witness. I said that in section 118, child witness word you will not find, because 118 basically have that who can be witness, who can be testify. But because the child is the special situations, and so in that that's why we have this topic of child witness. Section 154, question by a party to his own witness. Questions means a cross examination. Generally, the persons, the party who call the witness, they only ask that tell the story, that how all these things happened, or what you have observed, or what you want to say with respect to this case. Okay. So section 154 say question by the party to his own witness, the court may in its discretion. That means it is not always a right. The permission has to be from the court. That why court allow it. And the state of Bihar versus Laloo Prasad case, in which the witness turned hostile and the prosecution want to cross-examine the witness, but because you know at the examination in the chief they missed it, and in during the cross-examination, when this witness that the prosecution called to give the evidence against Laloo Prasad, he then extended the whole story that favored the defense. And so at that stage the prosecution pray for section 154 for permitting to ask the question as a cross examination, and the trial court has denied. Then the question comes to the higher authority and finally to the Supreme Court, and so the case was settled down. Again, section 154 does not mandate that the judge, the court has to permit. It says that the court in its discretion permit the person who call a witness to put any question to him which might be put in cross examination by the adverse party. So section 154 is not saying that at what stage a person can pray, a person can ask from the court, person can ask the permission from the court to ask the question, whether it is in the trial stage or the at the appeal stage, etc., or at the examination stage, or at the re-examination or the cross examination. So that is not there. Even it is not that it is always applicable in the hostile witnesses case, or the witness that turned the hostile, or that not giving the testimony in favor of the party who called him. But yes, in the hostile cases, this is one of the important section that is helpful, and you can put the questions that can be put by the adverse party. The rationale I have said, that if this section would not be there, if the court would not permit, then the person you called, suppose he cheated you, he cheated the person who, the party who called, and now he telling the another story by which the offender is benefited, and the offender side will not ask any question by which the veracity come, उनके लिए तो favor कर रहा है. And so as a general rule, the party who called them, they cannot ask anything that can be asked in the cross examination. And so in that situation, such witness will be very, treacherous, very dangerous to the whole judicial system. And that's why Section 154 allowing the party who called such witness to be put or to ask any question that can be put in the cross examination. Then there is clause 2 of Section 154, that nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. That means even the person asking the question that can be asked in the cross examination, the earlier portion in which there is no dispute, so that on that portion the reliance can be put by the court. Okay, and that is to clarify that suppose A is a hostile witness, so whatever he has said, and the party said that, sir, it became hostile, witness became hostile, and so allow us, permit us to ask the question. And after asking the question, some veracity on a particular point come. Okay, then this thing does not disentitle that to rely on other part that is not in the issue, or that is uh, on which this hostile witness has not changed its position. Like maybe this example will clarify the position more. A is called as a witness, and he has to narrate the story what he has saw, that how B, C, D, and E together killed F. But in his statement before the police, he said that he saw at that time he was standing there and he saw that B, C, D, and E killed the F. But at the time of his deposing, गवाही के समय, there may be some connection with the E or some other thing. He said that only B, C, and D, and not F, killed, not E, killed F. So E के नाम को उन्होंने नहीं किया. And on that, the prosecution said that this witness became hostile, asked for the permission to ask the question that can be asked in the cross examination. They asked that in your earlier statement before the police, you said that he was also in the killing of the F. So this, whether he was in the killing or not, that is something that is in the disputed, and the question was asked. But the earlier part, the part that B, C, D, that is undisputed, that they took part in the killing. So on that the reliance can be put, because when you see it, one can say that when the when this witness is not true in respect to E, how we can consider that he will be true even with respect to B, C, and D? And just to clarify that position, there is this clause 2. Okay. Now come to the case we have in the case material. It's on the page number 176, a very little case, only in 1.5 pages. State of Bihar versus Laloo Prasad, and it was from the Honorable Supreme Court. 2002 9 SCC 626. State of Bihar versus Laloo Prasad, 2002 9 SCC, Supreme Court cases 626. Justice K.T. Thomas and S.N. Varia wrote this judgment. And here the facts are very simple, that the trial judge, before whom under section 154 the prosecution asked the permission to cross-examine the witness number 39, Baleswar Chaudhary, on his deposition. Baleswar Chaudhary was called by the prosecution and he mentioned about a document executed in 1993 styling the same as a sale executed. After the same in the chief examination, that means examination in chief, the same witness further stated that he received the consideration thereof in 1983. And the said last part of the chief examination is was obviously not in consonant with the prosecution case. That means, in the nutshell, if you are not getting, that means some portion he said that was not in consonance with the prosecution story. जो प्रोसिक्यूशन जिस तरह से सब चीज लेके आया था, जिस तरह से उसको गवाही के लिए था, वो जो पहले उसने स्टेटमेंट दी थी, सेम थिंग ही हैज नॉट सेड, ही चेंज हिज स्टोरी. At that moment, prosecutor has not realized that he became the hostile or he can take the help of section 154 to cross examine him. Then the cross examination happened, and in the cross examination he further disclosed the detail of how he received the consideration. And at this stage, the public prosecutor requested for permission to treat the said witness as a hostile. So after the cross examination, the public prosecutor under section 154 asked for calling this witness as a hostile witness and to take the benefit of section 154. The trial court has refused, and it goes to the High Court and then ultimately to the Supreme Court. Now the argument, the issue is that whether after the cross examination the court can give or not, can give or can not give the benefit of section 154, or to allowing a person to ask the question to the witness that he called, to the question that can be put by the adverse party. The argument from the both sides, the para 5 of this case said that the learned counsel invited our attention to a earlier case to support his contention that it is open to the party who call the witness to seek the permission of the court at any stage of the examination. And even by reading plainly reading of section 154, also it is clear that there is nowhere mentioned that at what stage a party who call the witness can ask the permission to put such question that can be put in the cross examination by adverse party. And the authority also has been given. Yeah, Bhai Chhagan Bhai Thakkar versus State of Gujarat, AIR 1964 Supreme Court. But the main question is that even section 154 is not saying that at what stage one can ask the permission. It is not mandated that one asks for the permission, it is always has to be given. The discretion is on the court, and court has to exercise his discretion. Discretion means in either side. And then on the para number 7, the Supreme Court observing that nonetheless a discretion has been vested with the court whether to grant the permission or not. Normally, when the public prosecutor requested for permission to put cross question to a witness called by him, the court used to grant it generally. But it does not mean, because what section 154 says, that court in its discretion. Here, if the public prosecutor has sought permission at the end of the examination chief examination itself, the trial court would have no good reason for declining the permission sought for. But the public prosecutor did not do at that stage. That is precisely the reason that why trial court just declined to exercise his discretion when the permission was sought for after the cross examination was over. The witness has said only the details in cross examination regarding the matter which he had said in the examination itself. It would have been a different position if witness stuck to his version he was expected to say by the party who called the witness in the examination in chief, but he sought the propensity in favor of adverse party only in the cross examination. In such case, the party who called him has a legitimate right to put the cross questions to the witness. But if he resigned from his expected stand, even in the examination, the permission to put cross questions should have been sought then. Okay. Then on the para number 7, the some last line that the very fact that sought permission of the court soon after the end of cross examination was enough to indicate his resolve not to own all what witness said in the evidence. It is again open to the public prosecutor to tell the court during the final consideration that he is not inclined to own the evidence of any particular witness in spite of the fact that said witness was examined on his side. So the Supreme Court is observing that when this witness that called by the prosecution, when this witness is not telling the story as per the stand the prosecution has, so that means the prosecution will not believe on the story of this person. And at the argument stage also, at the consideration of the argument stage also, he can tell to the court that we are not relying on this particular witness and his testimony can be set apart. Okay. So, see the line the Supreme Court is observing that the public prosecutor to tell the court during the final consideration that he is not inclined to own the evidence of any particular witness in spite of the fact that said witness was examined on their side. When such options are available to the public prosecutor, it is not useful exercise for this court to consider whether the witness shall again be called back for the purpose of putting cross question to him. And so the Supreme Court has dismissed this appeal, saying that you have another option. When you are want to cross examine, after the cross examination, if you want to do that thing, want to take the benefit of section 154, you had the chance after the examination in chief. But because the section is silent and so the controversy, so court said that might be the reason was that the trial court ने क्यों मना किया. The reason was that what you can ask at the stage of the examination in chief, you ask at that stage. And the discretion that this court has used, it will not cause any, great injustice to you, because you have another option. When you are saying that you will cross examine, that means you are not relying on the testimony of that witness. And so at the argument stage, at the consideration of argument also, you can say that though we have called it, but we does not want to, in spite of that, we does not want to rely on the witness number this. And so when this type of the option is available, then why to call back the witness? Because see, when trial court rejected the application under section 154 for has not given the permission, so witness तो चला गया. Now आपके उसके बाद में कितने साल बाद में High Court and then Supreme Court. Now what will be the order if the court allow if the court said that the trial court has wrongly decided and that permission can be given, what will be the consequence? Consequence तो ये होगा ना कि उस witness को दोबारा से call किया जाए. And so the court said that when you are not relying on that witness, so argument के stage पे आप कह देना, इस समय अब उसको दोबारा कॉल बैक करें, दोबारा सारी चीजें करें. And that's why they said that you have the option available, and so it's not proper to call back for the purpose of putting the cross question to them. Though if you see in the strict sense, the discretion is there, but judge has not used that discretion in the manner in which it was prescribed in section 154. In the order, it was not written clearly that why they have not permitted. Okay, but Supreme Court also has said that when you have the option available, then it is not need to call again that witness. But definitely two things clarify this this case, State of Bihar versus Laloo Prasad. One is about that section 154 gives the court a discretionary power. It is not that when the witness turn hostile, as a matter of right, the party who called the witness say that we will cross-examine. Okay, but this discretion has to be judicially used. And the second thing is that at any stage they can ask it. So even after the cross-examination also they can ask it. And if you read the judgment, the force is on the is not on that after the cross-examination that they cannot ask. The para number 6 says that might be the reason of the trial court was that you after the cross-examination asked, and that's why they have said. They have not said that after the cross-examination it cannot be. Okay, so that's the thing. Now come to the part B of the chapter 5, and this is about section 137, 138, and 139. 137, when you read the three examination that I have told, examination in chief, cross-examination, and re-examination, and 138, that what will be the order of that. So I'm reading section 137. The examination of a witness by a party who call him shall be called examination in chief. Cross-examination, the examination of witness by adverse party is called cross-examination. So as such, it's not that, what thing or what precisely will be the examination in chief. So basically, when the party that call the witness, when they examine, when they ask you something, that is known as examination in chief. When the opposite party, other than the party that call the witness, when they examine the witness, that is known as cross-examination, when they ask the question. And re-examination is examination of the witness again by the party who called, but it is subsequent to the cross-examination by the party. And in that manner, examination in chief and re-examination are different. Examination in chief and re-examination both are examination of the witness by the party who called him. But the situation is, or the difference is, that the re-examination is something that happened after the cross-examination, or examination by the party who called the witness after the cross-examination will be considered as re-examination. Now the question is that who will first examine, whether the first will be the cross-examination or examination in chief. And for section 138, uh, prescribe, or can say have this order of examination. Witness shall be first examination in chief, then maybe it is not always that the adverse party want to ask the question to every witness. In many trial, you have seen that when the witness is called, the party who called the witness ask the question, and then just say that the adverse party whether you want to ask the question, and they say no sir, and then it goes. And that's why if the adverse party so desire, cross examine, And even after there is some need of clarifications or to rectify the point or to clarify the point, then if the party calling so desire, then re-examine. That means re-examination and cross-examination is always on the desire of the parties, and the examination of chief is has to be done, but these things may be missing. Maybe in one uh, deposition, one testimony, you will find only examination in chief, or maybe in one deposition you will find examination in chief also, cross examination be also, and re-examination also. The examination and cross examination must relate to the relevant fact. Now, again, this is in line with the section 5 and section 136 of the Evidence Act. But the section 136 says that every fact has to be proved by relevant facts. And section 5 says that the evidence of the relevant fact you can give. And what is the relevant fact? The whole chapter 5, section 6 to 55, define that what are the relevant fact. Here also, what you will ask, what you will ask, what you will examine, that has to be the examination and cross examination must relate to the relevant fact. And in the trial, sometimes I think you aware that sometimes the adverse party even asks some question that seems to be not connected or not relevant, and then the opposite party or the party who called the witness, they object, and then judge has to decide whether this examination is on the relevant fact or not. If it is the relevant fact, it relate to the relevant fact, then yes, allow, otherwise objection, sustain. And so the latter second part of the section 138 says that examination and cross examination must relate to relevant fact, but the cross examination need not to be confined to the fact to which the witness testified on his examination in chief. Like A गवाही के लिए आता है, एंड ए डिपोज दैट ही सो कि बी ने सी को किल किया, एंड देर इज सम एविडेंस, समथिंग दैट इज इन द डिफेंस साइड कि ये जो डिपोज कर रहा है, जिस तारीख को मर्डर हुआ था उस दिन तो ये न्यूयॉर्क में था, इसने दिल्ली में कैसे देख लिया मर्डर करते हुए ए को अभी को. एंड सो section 11 said that anything that inconsistent with the fact in issue or the relevant fact would also be relevant. And so in that situation the questions can be asked. But now the question, he said that okay, आप अमेरिका में वहाँ पढ़ाते हैं, so whatever the thing they are asking, they seem to be that they are not in confined with the all these facts, but at last they have to prove that whatever this cross examination, this is relevant, because section says that it is when something that is inconsistent or consistent with fact in issue or related to in connection with fact in issue or relevant fact, that would also be relevant. And so such question would also. So in the examination and re-examination, your examination must be related to relevant fact. You will not allow to ask any irrelevant question that is not relevancy, as we discuss in section 5 to 55. But in the cross examination, it is not that whole cross examination has to be limited to the what the fact he said in the examination in chief. Even they can go beyond that, but that also they have to say, or they have to ensure that they are not asking any irrelevant thing. Whatever they are asking, they has to relate it, they has to make it that these are the relevant, either to impeach the credit or the veracity of that person. Because there is one section 154 155 that impeaching credit of the witness. And here, impeaching the credit of the credit of witness may be impeached by the following ways: by the adverse party with consent of the court, by the party who called him, by evidence of person who testify that from their knowledge the witness believe him to unworthy of credit, by form of former statement, proof of witness has been bribed, etc. So that all these things are the section 155 about impeachment of the credit. So that can be done, but all these things has to be related with that. Just give me 1 minute and then we will come. Okay. Now the next para is direction of re-examination. The re-examination shall be directed to the explanation of matters referred to in cross-examination, and if new matter is, by permission of the court, introduced in re-examination, the adverse party may further cross-examine upon that matter. So when the re-examination is done, and if suppose a new matter come, and the opposite party say that in this new matter also we want to ask some questions, so that also will be done, and that would be again be the cross examination of that new matter. Okay. Now the next provision that we have to discuss is section 139, cross examination of a person called to produce a document. Now if you see the definition of oral evidence, section 3 para 6, what it says, that the person that gives the statement in the court in an inquiry, all the statement which court permit or required to be made before it by a witness in relation to matter of fact under inquiry. Now the thing is that suppose a person come, but he does not come as deposing the statement, as his deposition, rather he come because he bring the document. And so this situation covers section 139. A person summoned to produce a document. A person is summoned to produce a document. Now you tell me that this person was not called to make the statement. He was not allowed, he was not required to make the statement. He called only to produce the document. Like if there is a case and we call that the government, that PMO office has to produce the document, then the person who is summoned, and he bring the document, he will not become a witness, because he came to just to hand over the document. He has not came to make the statement. And para 6 of the section 3 says that all the statement will become oral evidence, and the person who gives the oral evidence as a witness. Now this person has not come to make the oral evidence, and so this person is not called as witness. This section 139 says a person summoned to produce a document does not become a witness by mere fact that he produce it. And when the person is not a witness, विटनेस नहीं तो एग्जामिनेशन नहीं, जब एग्जामिनेशन ही नहीं तो क्रॉस एग्जामिनेशन भी नहीं हो सकता. So cannot be cross examination examined unless and until he is called as a witness. तो विटनेस कॉल करेगा तब तो है ही. So when a person is summoned to produce a document, he is called not to make the statement, and when he is not called to make the statement, that means he is not giving the oral evidence, and that means he is not giving the oral evidence, he is not a witness. And if it is not, he is not a witness, no examination in chief and no cross examination. So cross examination cannot be. This happened in many cases, this happened in many situations, and that's why Section 139 is very important in line with the examination. Section 155, that we talk about the impeachment of the credit of the witness. So, that there was a bribery, there was an offer of bribery, etc., etc. So, all those situation, all those things you can give to impeach the credit. Like illustrations, I'm reading: A shoe B for the price of goods sold and delivered to B. C says that he delivered the goods to B. Evidence is offered to show that on previous occasion he said that he had not delivered the goods to the B. So the previous statement. Section 155 has three way. In the three way you can impeach the credit of the witness कि आपका witness जो witness है वो झूठ बोल रहा है. First, by the evidence of the person who testify that they from their knowledge of the witness believe him to unworthy. So कोई भी ऐसा, like witness is saying that he was in Delhi and he saw that A killed B, but the party proved that at the relevant time he was in the New York. Your witness was in the New York. How he can see? And so they can call him as the worthy. The second situation is about the bribery, etc. That the proof that the witness has bribed or has accepted the offer of bribery or has received any other corrupt inducement. But here these things you have to be proved as in the material. Some evidence you have to produce. Just a mere allegation, you cannot say that he has been bribed, etc. And the last one is the former statement inconsistent with any parts of its evidence which is liable to be contradicted. Like when the police investigated this part and police contacted, he gave the statement. And later on the stage of deposition, when he deposed before the court, he make another statement. Now, by showing this earlier statement, this former statement, the credit of this person can be impeached कि पहले तो आपने पुलिस के सामने तो आपने ये बयान दिया है और आज आप कह रहे हो कि आपने देखा ही नहीं या आपने ये कहा है. So that thing. Now, the second illustration that is also interesting, that A is inducted or murder of B. C says that B, when dying, declared that A had given B the wound of which he died. Evidence is offered to show that on the previous occasion C said that the wound was not given by A on his presence. The evidence is admissible. So again, that impeachment, that means section 155 saying that by these are the things by which you can impeach the credit of the witness. Now see the repercussion. When you are giving the proof of the bribe or proof of the any corruption or proof of any formal statement or proof of any other thing, that means that is also taken in this particular trial. There this question was not the issue, this was not the main issue, and so that means it enlarged that these evidences are also will be relevant and can be adduced. Okay, so that's why in illustration you will find that the evidence is admissible, evidence of previous statement is admissible, evidence of bribe is admissible, etc. So with this our chapter 5 is complete, and now we've left two chapters, chapter 4 and chapter 6, very small chapters. On Monday, as I said, on the Monday, because time we have taken. On Monday, we will discuss both the chapter. Accomplice evidence. Read section 133 that make the approver or the accomplice, or you can say Sarkari Gawah, Sultani Gawah, as admissible his evidence. But section 114b that talk about may presume. It says that as a rule of prudence, it is advisable that one should not, totally believe on the testimony of approval. So the testimony of approver has to be corroborated. Only solely on the testimony of the approver, conviction has not been, conviction should not be there. And so this is not illegal. Section 133 they say that it would not be illegal. That means legally only on the testimony of the approver a person can be convicted. But it is rule of the prudence that his testimony has to be corroborated in material particular. Material particular means जो story बता रहा है वो story और भी किसी इंडिपेंडेंट एविडेंसेस से थोड़ा बहुत जस्टिफाई करना, थोड़ा बहुत जो है वो मैच होनी चाहिए. Okay, so this is this chapter 4, very small chapter. Three cases are there: Babuni Sahu versus the king, Harun Haji Abdullah versus state of Maharashtra, Ravinder Singh versus state of Haryana. And then we will start the presumption also. So one lecture will be on the accomplice and the one lecture will be on the resumption, because on the Monday we have two classes, and so in these two classes I will complete the syllabus. On the presumption also there is one small case. So with this whole syllabus will be completed, and then Monday onward you can prepare for your examination. So with this, today class is over. If you have any question, any query with respect to our today's discussion, yes, you can ask me.